What up, dope Biz Nation? I'm your boy Tay Biz. Today we're going to talk about prosecutorial misconduct, how it impacts a trial, how it also impacts the defendant. And so the reason why we want to unpack this is because one of the things that have been mentioned a lot in the YSL trial, especially in the defense motions, is that there is prosecutorial misconduct. We're going to unpack what it is, and we're going to unpack how it impacts people's lives. Then we're going to break it down from there. Your boy Tay Biz, man. Let's go.
Prosecutorial misconduct is what it sounds like. It's when the prosecutor misbehaves to an extent where the prejudice is so overwhelming of what he or she did that the fairness is gone. It's a due process thing. It's a protection thing. Let me give you an example. Let's say at trial, the prosecutor in her closing argument says, members of the jury, you know the defendant's guilty because he wouldn't get up here and tell you his side of the story. Not allowed to do that. Not allowed to do that, right? A defendant has the right to remain silent throughout trial. It's a Griffin error, and that's prosecutorial misconduct. Another example is a DA says to a defense witness, I know you're here illegally. And if you testify, I'm going to make sure that the authorities know about it. Obviously, prosecutorial misconduct. Let's say at a 402 ruling, which is pretrial rulings, there's a tape, a 911 tape, say. But the judge says, you know what? The 911 tape is not admissible. During trial, the prosecutor mentions the 911 tape and what it says. Prosecutorial misconduct. So prosecutorial misconduct is basically when the prosecutor does something they're not supposed to do. And you kind of know it when it happens. It catches your ear, especially the attorney. But even the defendant will hear, wait a minute, that's outrageous. But that doesn't necessarily mean anything. The prosecution can get away with it unless it's prejudicial. And then it has to be prejudicial to such a degree that it cannot be cured. A lot of times the prosecutor may say something they're not allowed to say, and the judge can either strike it from the record or tell the jury to disregard. But if you're the defense attorney, especially if trial's not going well, you get up there and you scream bloody murder and you demand a new trial because basically the bell cannot be unrung. The effect of prosecutorial misconduct is that usually someone has been prejudiced, okay? Whether it's the jury because they were told something they're not allowed to hear, or it's the defendant because now the jury knows something that they're not supposed to know. So the effects of prosecutorial misconduct is basically things have become unfair. And the whole point of due process, and in my opinion, the definition of justice, is fairness. So with prosecutorial misconduct, you have a direct affront to fairness. So the effects can be far-ranging. The prosecutor may say something they're not allowed to say, and then it's up to the judge, right? So depending on what the judge does, whether he just cures it with a jury instruction or declares a mistrial and you start from the beginning, it all depends on what was said and primarily depends on how much prejudice did it cause. So what do you do if there is prosecutorial misconduct as a defense attorney? Well, let's assume that it's happening during trial because technically it can happen before trial. The prosecutor doesn't give over some evidence. The prosecutor says something inappropriate to a witness, but it usually happens at trial, right? So let's say the prosecutor says something to the jury they're not allowed to say. Well, as a defense attorney, you have to be thinking like a boxer and a chess player. You have to evaluate just how damaging it is. And that's the chess game, right? I mean, can this jury still look at your client in a way where they may give him the benefit of the doubt now that they know something? Let's say it's a prior conviction for the same thing that the judge said can't come in. If it is that damaging, then the boxer gets up and pounds on the table and demands a new trial. But let's say it happens, but you like how the trial's going. You don't necessarily want to start all over. And a lot of times the client sure doesn't want to start all over. Well, then the boxer can save it for closing argument. And in closing argument, hammer the DA for the inappropriate comment. Hammer the DA that because they don't have the evidence, they're coming up with whatever they can. And it's a shame that they have to resort to such a level to try to blindly lead you somewhere that you're not even allowed to go. So you can use it in your defense, but if it's too prejudicial, you got to fight for a new trial.
That was an excellent breakdown about prosecutorial misconduct and how it can be definitely a situation where it shows prejudice and things of that nature. He did mention something about the fact that normally it happens during trial, but he also mentioned that it can happen before trial. And he gave a couple examples. But there's also one extra example that you could actually refer to is jury selection. Let's say, for instance, a prosecutor is selecting their jury, but they're basing it on race, or they're basing it on sexual preference, or they're basing it on something that's biased. That is also a part of prosecutorial misconduct. And so that can also be used as prejudice, as evidence of saying, hey, that this lawyer is not behaving properly, things of that nature. Mentioning things in the trial while the evidence is supposed to be excluded, mentioning those things like the 911 tape example that he gave. Again, another thing of prosecutorial misconduct, trying to sway the jury before actually presenting burden of proof is another way of having misconduct. And so when you have a pile of misconduct going on, then what happens is that it could lead to a mistrial. And so depending on what kind of judge you have, Glanville, depending on what kind of judge you have, the mistrial will be granted. However, we're going to go ahead and look at another video here of prosecutorial misconduct that's been happening in New York. And this video is definitely going to just blow your mind at how bad this is from a nationwide perspective. Let's go ahead and check out this video.
So just before we get started, the highlight of this panel is going to be the speakers that we have today. I just wanted to share some statistical background on the issue in order to frame today's discussion. So briefly, a recent national study of 2,400 exonerations found that almost a third of them included prosecutorial misconduct. The Death Penalty Information Center identified more than 550 cases nationwide in which a capital conviction or death sentence was overturned as a result of prosecutorial misconduct. The National Registry of Exonerations issued a 2020 report examining the consequences of prosecutorial misconduct, in particular exoneration cases. The report found that prosecutors who committed misconduct in criminal cases that led to exonerations were rarely disciplined. In fact, it happened only 4% of the time. And lastly, a 2013 report from the Center for Prosecutor Integrity identified 3,625 cases of prosecutorial misconduct between 1963 and 2013. Of those, only 63 prosecutors, less than 2%, were ever publicly disciplined.
I see the problem of prosecutor misconduct as being egregious. I see it being as something that's not regulated enough. I see it being as unchecked. The prosecutor is the most powerful person in the county. They have all of the power. They have, all the control. So if you get an unfair prosecutor, a prosecutor that's, doesn't have justice and fairness and candor at the top of his agenda, then you have an office that's running rampant. If you got a fair prosecutor, on the other hand, who's following all the best practices and doing things in accordance to ethics and proper protocol, then you got a good prosecutor. But how do we know? We know based on statistics, right? We know based on the evidence that we use Brooklyn, for example, that there's been many wrongful convictions coming out of Brooklyn. And Ken Thompson and Eric Gonzalez has been courageous enough to admit to these things. They're admitting that prosecutor misconduct is a big problem in this borough. But we need to know this in every county, in every borough, because the statistics doesn't lie, right? And why aren't some of these people in jail, right? When they allow police officers to bring false witnesses in over and over and over again to send innocent men and women to prison. Why are they not sent to prison, right? I believe that anything left unchecked in our society is abusive to the people in which they serve. And prosecutors are not checked at all. They get wrongful conviction after wrongful conviction. They get overturned over and over by the appellate courts, and nothing happens to them. In any other profession, right? If you commit these type of malfeasance, these type of ethical violations over and over again, you're fired. Why not in the prosecutor's office? So I think it is egregious. I think it's affecting communities, it's affecting people's lives, and these human beings we're talking about. And we need to put checks and balances to hold them accountable.
I believe that prosecutors, especially the bad ones, they should be there should be more checks and balances. If anybody who has the power to take away your life or to send you to jail for the remainder of your life, there should be more oversight, not less. And in this case, we have prosecutors working in each counties. You got the top prosecutors, and then you have assistant district attorneys, and some of them who are doing basically what they want. There is too many individuals in jail with wrongful convictions who are actually innocent of the crime, and only 10, 15, 20 years later, you figure out that no, they did not commit the crime. And the prosecutor, she still have her salary, he or her, they still have the prestige of going to colleges and university teaching law, and the individual who they convicted wrongfully, his life is a mess. You know, I was wrongfully convicted when I was 20 years old. I was arrested of a shooting that I did not commit, and I was coerced into taking a plea. You know, I was going through hell at that time at the facilities that I was in, and my attorney wasn't giving me no information. He wasn't appearing in court, and when he did appear, the only thing he seemed to be talking about is that if you don't take this plea, you're gonna get 8 1/3 to 25. And as a 20-year-old, I just couldn't do 8 1/3 to 25. I didn't commit the crime. The individuals who got, the one person who got shot, he was not cooperating with the district attorney. There was no way for them to find me guilty had I insisted of going to trial, but I ended up taking the plea because I was coerced to. I was pressured to take that plea. And to this day, that decision have ruined my life. You know, and prosecutors don't care as long as it's not their sons and daughters that is getting arrested. They really don't care about the consequence about what individuals do. They just run with whatever evidence they claim to have. And even decades later, when you try to remove the convictions, they tend to resist in a hostile and or fear manner. There shouldn't be there shouldn't be bad prosecutors. You know what I'm saying? There should not be individuals that has so much power, like Mr. Hamilton was saying, and there is no type of check. You cannot allow prosecutors to police themselves. There should be a separate entity that should be there, you know, to answer, to be able to put things into perspective, like whenever something go wrong. You know what I'm saying? Like like they said, like ain't no profession. Imagine having a job where anything you do is valid. Anything you do is not going to be no repercussions. You could do anything. You could say what you want. You could do whatever you want, and there isn't going to be no repercussion against you. That is not right. It's not good to have a job like that. We need to have we need to have standards in place to make sure that they don't do that. And they have a tendency of going after people of color at an alarming rate, even though it happened to a white and other individuals, but we bear the brunt of it. And it's just not right, you know. So I believe that is like one of the biggest prosecutor misconduct is one of the biggest shames that each county faces, you know what I'm saying? And the vast majority of law-abiding citizens, they are not aware of the misconduct that these prosecutors is doing. And we should do more to make sure that they are aware of what the prosecutors is doing. When they do something wrong, there should be consequences.
Well, I just want, first of all, thank you so much to people for being here. I'm so glad. It's a really important issue that, like Mr. Hamilton, Mr. Clark said, is really under-discussed and under-known. But I just agree with everything they said, and they know, you know, better than anyone how it can ruin lives, ruin families, ruin communities. I just wanted to point out, like, we talk about police misconduct and how it's not bad apples. Like, it's not a few individual people, it's like a structural problem. And the same is really true of prosecutorial misconduct. Again, it's not like, it's just the culture and structure of prosecution in most places that, you know, people get promoted on conviction rates without looking into what that means, that it's a win at all costs mentality. And in terms of ethics rules, which I know we're going to talk a little bit more about, you know, prosecutors are the only attorneys. So all attorneys have ethics rules, and prosecutors have a minister of justice rule. They're supposed to be delivering justice, not convictions. And it explicitly says that doesn't mean convictions. It certainly doesn't mean wrongful convictions, but it doesn't even mean convictions. And I think we need to, you know, really take a look at ourselves as a society, but also, you know, really be, well, I guess we'll get to this in further questions, but really be monitoring what's going on, because exactly like Mr. Hamilton, Mr. Clark said, like, this is a real problem. It's not, of course, it's not every prosecutor, it's not even every prosecutor's office, but it is all over the place, like Mr. Hamilton said, and it's just, it doesn't get enough attention in terms of how life-ruining it can be.
So the next question that we have for the panelists is, what have each of you done, or what are you currently doing to address prosecutorial misconduct? Thank you.
I'll go first this time. There was an English jurist, William Blackstone. He said that it is best to let 10 guilty people go free than to convict one innocent individual. And that is certainly not what happened in New York State. But so what the Vocal New York team is doing right now is that we have a bill called the Challenging Wrongful Conviction Act, which would try to, it is not focused on holding prosecutors accountable, which there should be different components to the problem, because the problem is huge. But where we focus at is to allow the individuals who is convicted. He might be in a jail somewhere in upstate New York, or he might be out here in the street like me, you know, an opportunity, a second opportunity to go before a court, get all of the evidence that was used against him, and for him to be able to build the case to prove that he was innocent of the charges, or that you know, he was innocent from the beginning, and the prosecutors didn't have a chance to think. So what do we do? In New York State, whenever you are convicted of a crime, whether if you take a plea or if you go to trial, you have a constitutional right for what is known as a direct appeal, and a direct appeal simply means everything that was stated in the courtroom that the stenographer recorded, that is what your argument have to be within what's in that stenographer writing. But there are issues that happen outside of that. Like, let's say if you went to trial and a prosecutor failed to give you what is known as exculpatory evidence that would help you prove that you did not commit the crime, then that is something outside the record. So you cannot file an appeal based on exculpatory evidence. You only could use what was said and done at the hearings and at the trials. So when you have outside evidence, what you got to do is you got to file what is known as criminal penal law 440.10, and that provision today, it is extremely old. It has a lot of challenges to it, and hardly nobody. There was a group of lawyers who studied it and figured out that hardly nobody ever got any relief through 440.10. Very little over the last 30 to 50 years. So what we want to do is we want to reinvent that provision, give individuals who is wrongfully convicted of a crime the opportunity to get access to a lawyer, because once you get convicted of a crime and you file a 440.10, is not mandatory for you to get a lawyer. So you got individuals who are convicted of a crime, they have to go and learn the law and to be able to write a motion and go to court. And it's not right. Like, we should have a lawyer there, representing them at every stages. Also, you're not entitled to a hearing. It depends on if the judge feel like giving it to you. The Challenge and Wrongful Conviction Act will make it mandatory for them to give you a hearing. If you took a plea, there was a famous case in the New York State Court of Appeals. It's called People versus Tiger. And in that case, the prosecutor argued that even if you're innocent of the crime, and if you took a plea, that you should not be allowed to go to court and plead and state that you're innocent. And the New York State Court of Appeals agreed with the prosecutor, and so now we got a law on the books which other states, other state raised concern, like Illinois Supreme Court Justice. Their Supreme Court Justice said that is a big miscarriage of justice. How is it that we're living in a state where prosecutors is saying it doesn't matter if you're innocent or guilty, if you took a plea, they don't want you in court? You know what I'm saying? And this is what the Court of Appeals did back in 2018, and it's a wrong-headed decision, and it needs to end. So what the bill would do, it would give back individuals who took a plea, give them the right to go to court and present their case, because the Innocent Project have proved through DNA evidence that innocent people take pleas, and they take pleas for minor crime, and they take pleas for major crime.
What I try to do is protest against prosecutors who abuse their authority. Actually be removed. I joined Vocal and other organizations, raful organizations, to go and protest outside of their offices, and ask for their removal. We filed grievances against them. We joined all kinds of coalitions to remove rogue prosecutors. I think that is our civic duty as human beings, when we see a prosecutor doing something unethical or wrong, to speak out against it. And I stand firm in that as an advocate for wrongfully convicted people. As a paralegal and a deputy director of a legal clinic, we litigate against prosecutorial misconduct. We challenge it in every asset of the case. If we see it, we point it out, and we communicate with the prosecutors. We call them, we pick up the phone and say, this is a pattern, or this is something that we've seen with this prosecutor several times, and must stop, right? We ring the alarm, and we litigate civilly, file civil rights suits when we can. But one of the biggest things that I do is I advocate on changing the 11th Amendment that gives the prosecutors absolute immunity, right? That protects them at all costs. Every chance that I get to come on a forum like this, I ask people to let's figure out what we can do to get rid of that amendment. Because whenever you say that the prosecutor can have more protections than the president of the United States, I got a problem with that. Right now, we're saying let's hold Donald Trump accountable, but we can't hold a prosecutor accountable that wrongfully convicted me or Roger or so many other men. I think that oxymoron in our society needs to be changed. So, my biggest asset, I think, is my voice and my ability to mobilize people to join me in the fight to change these things. And I'm going to continue to do that. I'm going to join fights like Roger have and support him, or Focal, and any other organization that have a make sense bill to hold prosecutors accountable to make the criminal justice system more fairer. So that's what I've been doing for the last 11 years since I've been released. That's what I continue to do with organizations around the country. And more than ever, we tell people to go out and vote to make sure that they elect prosecutors in their jurisdiction that runs on the bill to say they're going to be fair, and then hold them accountable to that when they get in office. I don't think there is any prosecutor in New York City that would say that I won't come out and protest against them if there's enough families and people that comes to my office and say that there's a problem. So we continue to fight against them to make it fair. We continue to get rid of the systemic racism that exists in all the prosecutors' offices around the country. Black people are being arrested. They're being convicted and prosecuted at a higher rate than anybody else, stopped by police officers, and they're just being abused. So we fight against that injustice every single day with every breath of our body.
3,625 cases where it shows prosecutorial misconduct. Only 63 of those prosecutors from 1963 to 2013 have actually been disciplined openly, which means less than 2% of them has been disciplined openly. That means everybody else, what happens to them? Do they get fired? Do they get reprimanded at any point? No, there's no proof of that. Let's go ahead and look further into the prosecutorial misconduct, and we're going to go into the Challenging Wrongful Convictions Act, and then we're going to break down again how this affects even the public defenders. There are public defenders who are overwhelmed with caseloads, all because the prosecution office will not do what they're supposed to do. All right, so right here it says prosecutorial misconduct is when a prosecutor violates a law or code of professional conduct while performing their official duties. It can include a wide range of improper tactics in criminal cases. Discriminating in jury selection. I talked about that before. I mentioned the fact that you can do that. You can be discriminatory against potential jurors based on their race, ethnicity, sex, color, things of that nature. Tampering with evidence. This includes knowingly presenting false evidence or witness testimony to a court or grand jury, failing to admit evidence that exonerates the defense, or asking damaging questions with no factual basis. Improper arguments. This includes expressing a personal opinion about the case or the evidence, vouching for the prosecutor's case or witnesses, name calling the defendant or defense attorney, or shifting the burden of proof onto the defendant, such as telling the defense attorney, like Glanville did Brian Steele, oh, you're unprepared. Well, you're unprepared. Why would you do that in front of a jury? Other examples of misconduct: withholding exculpatory evidence from the defense. Exculpatory evidence is evidence that proves that the defense is actually innocent of this particular accusation. Improper use of media, practices like entrapment or pressuring a person to commit a crime. Inducing a plea bargain through threat or unfounded assurances. Coercion. Improper contact with witnesses, defendants, judges, or jurors. Improper behavior during hearings or trials. Prosecuting cases not supported by probable cause. Harassing or threatening defendants, lawyers, or witnesses. Yeah, like telling somebody, yeah, that you not only will you go to jail for 2 years, Woody, but you're gonna stay in jail until all 12 or 20 some odd defendants are done with their trial, which could be years from now. That's coercion, man. Making improper public statements about a pending criminal matter. If the misconduct is sufficiently culpable and harmful, it can result in the dismissal of charges or a declaration of a mistrial. Sanctions for prosecutorial misconduct can also include appellate reversal of convictions, finding the prosecutor in contempt of court, referring the prosecutor to a bar association grievance committee, and removing the prosecutor from office. Also, right, check this out. Courts have found the following things to be prosecutorial misconduct as well: bringing criminal charges in bad faith without realistic hope of winning a conviction, such as retaliation against whistleblowers, non-cooperative witnesses, We saw that when the Alec Baldwin trial, where Morrissey had a prejudice towards Alec Baldwin. Come to find out, that prejudice got found out in open court, and they questioned her statements that she made behind closed doors against Alec Baldwin, saying that she's going to make him pay and all this kind of stuff. Okay. So again, you're doing this in bad faith. You know, you don't have any real evidence. The evidence that she did have, what did she do? She hid it under a different case number that could actually show proof that Alec Baldwin was not necessarily the responsible person for what happened to the cinematographer. And so it's Brady evidence, it's exculpatory evidence, and the judge right then and there had a motion and she dismissed the case. Now, let's go ahead and look at this Challenging Wrongful Convictions Act, because I thought this was very interesting as well. New York State ranks third in the nation in numbers of wrongful convictions. This is crazy. It says here, our state has an extremely high rate of plea bargaining. 98% of felony cases in our state resolved by plea agreements, not trial. So like my man said, you're giving people pleas, but they're innocent, or they're saying that they're innocent. But because they can't afford an attorney, or because they can't go to trial and put someone on retainer, they have to take the plea deal. Otherwise, you're going to throw them in jail anyway. Yet people who plead guilty have the lowest rates of exonerations because there are so many structural barriers to exoneration after a guilty plea. This is particularly true in New York, where the Court of Appeals ruled in 2018 in People versus Tiger that people who plead guilty cannot challenge their convictions on the grounds of actual innocence unless they have DNA evidence to support their claim. Wow. Says the bill amends Article 440 of the Criminal Procedure Law, which governs post-judgment motions, to provide people previously convicted of crimes the opportunity for meaningful review to ensure redress for wrongful convictions, including in cases where the person pled guilty. So for decades, New Yorkers have felt the pressure to plead guilty, even to crimes they did not commit, because bail was set in their case in amounts they could not afford, or because the pretrial process lasted so long that after waiting months or years for the case to resolve, they could wait no longer. Under the state's previous criminal discovery law, the now repealed Criminal Procedure Law, Article 240, people were not entitled to see the basic evidence in a case. They couldn't even see the basic evidence in a case, including witness statements, police reports, until trial began. Countless number of people pled guilty because of the pressure to plead, even in cases where the evidence may not have supported a guilty plea, or they were in fact innocent. So again, we have issues with our judicial system that shows that clearly shows that we are in a place where you can't even get the right representation, the right counsel, and they know it. So they're going to do one of two things. They're going to screw up the process for trial, for pretrial process. They're going to screw that up. Or they're going to set a bond so ridiculously high, and it most likely it'll be cash surety, where they know you can't pay the bond. They know you won't be able to afford it, but they're going to put that bond on you anyway. And then on top of that, they're going to coerce you to plead guilty of something that you have not done, they have no evidence that you did, such as hearsay, which is not evidence. They have no evidence that you did this, but they're going to coerce you to take a plea. And if you don't take the plea, you're going to be messed up. This is absolutely insanity. So one of the things too that we see a lack of is a lack of counsel when it comes to public defenders. Public defenders, what are they? They're basically government employees as well. All they do is come at you with pleas. Why? Because that's what the prosecution wants in the first place. I told y'all my story. The first thing that my lawyer came to give me was a plea deal. There was a few things in my plea deal that I negotiated, And the state was very gracious enough to fulfill my negotiations. So I appreciate that. However, that's the first thing they do is give you a plea. This is the agreement that they want to give you. This is the plea that they want to give you. Okay. So they're going to do that first. However, you still have a right to trial. That public defender will have to be your trial lawyer. It is what it is. Okay. But they are government employees as well. I have a video showing here that we're going to check out right now, where the public defenders are so frustrated at the fact that defendants are being treated with measures that are so unconstitutional, they literally walked away. Let's take a look.
Sheriff deputies forget to bring an inmate before a judge for a scheduled hearing this past September in Atlanta.
Oh, okay. Well, he was requested, so I'm not sure what happened there.
So Janie Weaver argues the case on the defendant's behalf.
We put in a motion for dismissal due to lack of no counsel. I spoke with you several times. You also stated that his rights have been violated due to the lack of counsel. We're trying to get the resolve today.
She's talking about Tony Turner, held on sex trafficking charges he says he did not commit, one of 10 charged in the same crime. He sat in jail for nearly 5 months with no court-appointed attorney to represent him.
Which is why the cameras are here, because they are here to see how this outcome is going to come out.
Weaver is Turner's fiance. She filed this handwritten motion to dismiss the case herself.
Are you an attorney?
No, I'm not.
What do you do for a living?
I am a certified nurse assistant, and I also work for Amazon. So he's kind of like stuck. He doesn't have no representation at all, no help at all, none, besides the little bit that I give him.
Turner is not alone. According to records from the Georgia Public Defender Council, the agency responsible for appointing attorneys to people who can't afford one, at least 620 people charged with crimes in the state did not have a lawyer this past summer. Some in jail for months. Judges in Fulton County, the state's largest, calling it a constitutional crisis.
They are waiting for that lawyer to help them through this complicated, serious process. And it is an unacceptable crisis that there are people sitting incarcerated, not able to move their case forward because the system can't find them a lawyer.
In August, the Southern Center for Human Rights threatened litigation if the state doesn't fix the problem, writing in this letter to the agency that the Georgia Public Defenders Council is in breach of its clear mandatory statutory responsibility with respect to hundreds of indigent persons accused of crimes. Amateo Ali is the agency's director.
How do you respond to that?
We're assigning our clients attorneys as soon as we know about them. To say there's a constitutional crisis, I disagree with that.
The director says she joined the agency during the height of the pandemic, inheriting staffing shortages. The Defenders Council represents 85% of people charged with crimes in Georgia. Earlier this year, she helped increase employee salaries by 6% and created a system she claims automatically assigns attorneys within 72 hours, claiming the agency now has enough attorneys to represent defendants.
How can you characterize and say you have enough when you have so many other people saying that it's a crisis?
So these are people who don't know what's going on in-house.
Even judges.
Even judges. Because see, when you don't have the whole story, you only base your information on what you have.
She blames judges for not notifying her office when defendants show up to court without representation, saying that could be one reason her office doesn't always know about unrepresented clients.
I've only been in this position for 2 years, but in my 32 years of being with the public defender system in one capacity or the other, this last 2 years have been the most phenomenal.
Do you buy that?
No.
These 6 former state and county public defenders disagree.
I absolutely would not have left, but for the turmoil in the office.
All left their jobs since Director Ali joined the agency in March 2020.
At this moment, we're bleeding from our staffing right now.
And all blame her for not doing enough to support agency staff. Camille Reddick worked at the agency for more than a decade.
I did not leave I was terminated after I began to yell at the top of my lungs that the way we were handling business and the way we were treating persons who could not afford an attorney was in violation of the Constitution.
Mary Beth Snyder, David Cooper, and Linda Day say the agency didn't provide basic office supplies to do their jobs.
Things like paper, pens,
Right.
envelopes.
I couldn't find folders for
No.
a long time.
They took away everything. They told us we would have offices, and they're like, oh, no, just kidding. No offices.
While they quit the agency, she still represents defendants for the state as a contract attorney in Clayton County, just outside of Atlanta.
I have 500 clients now.
500?
500. My trial partner has 500.
Is that manageable?
No, it's not. You're pissing on fires as they come up because there's no other way to do it. So cases don't really get looked at until they show up on a trial calendar.
Do you think that's manageable?
She was not a contractor when she was
She
here.
is currently a contract attorney in Clayton County.
In Clayton County, and now let me explain to you how the system works.
Is that manageable?
It is not manageable, but it would be unfortunate for Clayton County to allow that to happen, and I don't believe that is true.
It was true. Take a look. The state's case management system shows Day's caseload actually increased to 687 just days after our interview with the director.
A shocking lack of transparency.
Brandon Bullard is the former director of the agency's appellate division responsible for appeals, an important layer of public defense that ensures verdicts are fair. 2 years ago, Director Ali proposed cutting $1 million from his office to address budget deficits during the pandemic.
One, it was the first I heard of it. I was the director of that office. Two, coincidentally, $1 million was roughly the collective salaries for myself and
For the entire division?
for the entire office, yeah.
Why would you not speak with him knowing that he's the head of a division in your agency before making those cuts?
I never met Mr. Bullard, and you're talking about 5 disgruntled employees who are no longer here.
I left because I had no faith that the present leadership was going to be invested in the quality of representation or would have any respect for the people who were doing the work.
Whatever reason people are leaving and you see that your ability to represent people is being compromised, it is incumbent upon you to respond to that and ensure that we don't get to this hellacious place that we're currently.
So as you can see, it's all across the board. It's the whole thing. The whole entire system is in shambles. All right. This lady said, you're only talking about 5 disgruntled players. Well, hold on. Don't disregard what's happening. This is happening on a larger scale, and she is trying to deflect the fact that this is a problem. We have people in offices who do not prioritize constitutional rights, and that's the problem. The problem is that you should be able to have counsel representation, period. And if you are in charge of the public defender's counsel, it is your responsibility to make sure that you have enough lawyers even on your side, so that way representation can be conducted in a constitutional manner. In other words, Fonnie Willis, who is the DA, who said that she needed more lawyers for these caseloads, these backlogs of cases, you did not do what you were supposed to do. You all have failed. So this is the reason why we have things like the Wrongful Convictions Act that New York is doing. I think that particular act should be a federal act, but that's my opinion. But the whole point of this video is to show that there is misconduct on one end, and there's also misrepresentation and lack of representation on the other end, which is still unconstitutional on both sides. So at the end of the day, it's a ping pong match between public defenders and prosecutorial misconduct or prosecutors, and they're all under the same umbrella, your government. So while we're so concerned about who the next president of the United States is going to be, find out who your council members are going to be, find out who your governor is going to be, find out who your district attorneys are going to be, find out things that's happening in your local proximity. So that way you can have some fairness and some type of justice where you are. Because right now, there is no in the world I would trust any system, any state at all. So, yo, this your boy Tay Biz, man. I hope you like this video. I hope you share this. And I hope you go ahead and subscribe to the channel, man. And become a member of Biz Nation, man. We got a lot more things we're going to be doing. We got a lot more things we're going to cover. And of course, we're going to be covering YSL and other cases as well, and other topics as well. But definitely come on by, man, to Biz Nation, man. Stay with us, man. Stay tuned to us. We got a lot coming up for you, man. It's your boy Tay Biz. Peace.